Welcome and thank you for joining part 1 of Seyfarth's webinar micro-series to kick off the release of the 2023 California Peculiarities publication, 2023 California Peculiarities, How California Employment Law is Different. This session will cover new developments in wage and hour and pay equity and pay transparency. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A feature located on the right side of your WebEx window. We will do our best to get to everyone's questions. However, if your question is not answered, our presenters will follow up with you directly in the days ahead. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the presentation. At this time, I'd like to turn the program over to Michael Afar.
All right, thank you, Brenda. Good morning, everybody. Thank you for attending today and for joining us. We're very excited to be presenting on our first part of the webinar series for our latest release of the Cal-Peculiarities paper. This is a very important step for the firm on a yearly basis. It's something that all of our California attorneys participate in, and we're very proud of the work product we're able to share with you and the updates we're able to provide here today. Let me introduce myself. My name is Michael Afar. I'm a partner in our labor and employment group out here in Century City, California. With me, I have Sharday Scahan, another partner, and Francesca Hunter, an associate in our office. And we're very excited to be here today with all of you. Next slide, please. We have a robust agenda, so I'll crank through some of the introductory stuff real quick. You'll see on your screen a list of 6 topics that we'll be covering today. Some hopefully that don't give you as much heartburn as others, but that are good and important developments in California law that you should be aware of. And obviously, this is just a very high-level primer on some important cases and new developments, but to the extent you have additional questions or other interest in learning more about this information, please feel free to reach out to any of us or your favorite Seyfarth lawyer at the firm, or reach out to get a copy of our Cal-Peculiarities manual so that you can read into things more closely. Next slide, please. And before we go into it, there will be a copy of the presentation that will be circulated to people. You can also request the Cal-Peculiarities paper directly. It would have been in the registration information as well. But if you need more direct access to it, feel free to reach out to any one of us. So to get it kicked off with our first topic for today, which is rounding, I'll send it over to Francesca.
Thank you, Mike. So for the best practices of rounding, we'll kind of go into a brief overview of the pivotal case. This is the See's Candy Shop's decision from 2012. Now, before See's Candy, California State really had been silent on rounding, and employers were frequently sued by employees who contended that they were not being compensated for all of their time worked. In See's Candy, the employer used timekeeping software that required employees to clock in at the beginning and out at the end of their shifts. The timekeeping system used by the company rounded all time entries to the nearest tenth of an hour. Now, in the See's Candy case, a former retail sales employee sued See's on behalf of herself and others, claiming that the time rounding practice failed to pay employees for all hours worked. The company claimed any unpaid amounts were de minimis or too trivial to matter, and that the rounding policy was in line with federal and state law. But the trial court granted summary judgment for the employee, leading See's to seek immediate relief from the Court of Appeal. The appeal of the court reversed and found that the rounding policy was lawful. The court held that a rounding policy is permissible under California law if it is fair and neutral on its face and does not result in the underpayment of earned wages over a period of time. Next slide, please. So this brings us to the Camp v. Home Depot decision from 2022. The California Court of Appeal recently held that employers who can capture and have captured the exact amount of time an employee has worked during a shift must fully compensate employees for all the time worked, rather than rounded time, even if the rounding practice is neutral on its face and as applied. Now, in the Camp case, the employer had a practice of recording employee time to the minute when an employee punched in or out, but then rounded the time to the nearest quarter hour. Two plaintiffs brought a putative class action alleging unpaid minimum and overtime wages under the California Labor Code. One of the plaintiffs had lost a total of 470 minutes over the course of 4.5 years, while the other plaintiff alleged being overpaid due to the rounding practice. During the trial court decision, the employer moved for summary judgment, arguing that the rounding policy was neutral on its face and as applied, and therefore in line with C's. The trial court granted the employer's motion for summary judgment, finding that its policy met the standards approved in C's, as it was both neutral on its face and as applied. Of course, the plaintiffs appealed the decision, and the Court of Appeal explained that pursuant to Labor Code Section 510, employees must be compensated for all time worked. In Camp's case, he was not compensated for over 7 hours of work, and this amount of time could not be considered de minimis. The Court of Appeal explained that where employers who can capture and have captured the exact amount of time an employee has worked during a shift, the employer must pay the employee for all time worked. According to the court, there is no provision in California law that privileges arithmetic simplicity over paying employees for all the time worked. Next slide, please. So because the C's decision was issued by a court of appeal and there have been subsequent decisions by the California Supreme Court that call into question the validity of rounding as applied to specific factual circumstances, the Camp Court invited the California Supreme Court to address the propriety of rounding in the face of new technological advances that make it possible for employers to capture the exact time that an employee clocks in and out. The Court of Appeal also invited the California Supreme Court to more generally address policies of neutral time rounding. Next slide, please. So what does this mean for employers, and what are the best practices or advice that we have? So given the recent Donahue holding that rounding cannot be applied to meal period time punches, and the Court of Appeal's invitation for the California Supreme Court to weigh in more generally on rounding practices, it is likely that at best, the circumstances under which rounding is permissible will be further circumscribed or will be held not to exist at all. So our practical advice would be to discontinue rounding employee time punches for both start and stop times and the meal break times. Thank you. Next slide.
All right, thank you, Chess. So one of the other areas that we've seen a lot of litigation in California is the regular rate of pay. It's important not just for calculation of overtime, but also the other areas in which the regular rate of pay gets factored in, such as meal and rest break premium pay now, also for things like sick pay. Next slide, please. And so I'm sure you're all generally familiar with the regular rate of pay, but it's different from the employee's base hourly rate in the sense that it also has to factor in all other forms of compensation that are received in the work week, including those base hourly wages, but also things like commissions or non-discretionary bonuses. But there are also different forms of compensation that are generally not included in the regular rate, such as expense reimbursements or various types of discretionary bonuses or things like PTO or sick pay. And the regular rate of pay can fluctuate on a week-by-week basis. Next slide, please. The regular rate of pay presents a lot of special challenges, not just because it's math, and most of us, including lawyers, have specifically gone into industries to avoid having to do math, but it's also important because even just missing one type of required form of compensation, whether it's for something that the employee earns or whether it's for some sort of benefit that may be needed to be included in the regular rate, or for a failure to include some sort of hours worked in the total denominator for that calculation, can result in an issue where the regular rate of pay is not calculated correctly. And that can have sometimes dire circumstances, especially in California, where a failure to pay correctly can trigger other forms of penalties, such as waiting time penalties or a wage statement penalty or PAGA penalties, things of that sort. Next slide, please. One way that we've seen employers try to get around this issue of having to pay or giving employees bonuses and doing something right by the employees, but then avoiding that type of bonus triggering a larger regular rate problem, is to give an employee something that's called a percentage of total earnings or percentage of gross earnings bonus. That type of bonus has been held to be lawful under the federal regulations and has been approved by the Ninth Circuit, but it was admittedly an open area in California because the California appellate court had never directly ruled on that type of bonus. And that changed in 2023 with the decision in Lem v. Ecolab. There, the California Court of Appeal held that that type of percentage bonus is lawful because it properly factors in the overtime pay that was already paid to the employee. The analogy is that all boats rise with the same tide. And so as long as your policy documents and your bonus plan for that type of bonus already factors in the overtime and you apply that standard percentage, 5% or 10%, into the equation, then that's going to basically increase the regular rate of pay. And I apologize for people who might be hearing some banging in the background. The building cleaners decided to have my windows washed right at this time, but they should be done in a second. This type of bonus and this type of percentage-based plan is something that has been held to be lawful. It's a way for employers, if you are looking to give your employees a bonus and do right by them, it's something that is held to be lawful and will give you less heartburn when worrying about things like the regular rate of pay. Next slide, please. All right, I'll kick it back to Francesca to talk about a recent Labor Code 2802 claim.
Thanks, Mike. So with indemnification for routine business expenses, it really starts off with understanding Labor Code Section 2802. Under this code, California employers must indemnify employees for money that they necessarily expend or lose in direct consequence of discharging their duties or as a result of following their employer's direction. Now, with the COVID-19 pandemic, this has led to an increase in litigation over reimbursement of expenses incurred by employees who work remotely, such as expenses for home internet access, utilities, and the use of home office space. Courts have concluded that the reasonableness of such expenses depends in large part on whether employees have the option to use the employer's facilities and services such as internet. In a recent filed class action, an employee challenged his employer's reimbursement of only incremental home internet costs incurred by remote employees. Or as an example, only those costs above what employees would normally incur if they were not working from home. The Northern District of California declined to certify the class, citing evidence that many employees had received reimbursements of more than a reasonable percentage of their home internet costs in compliance with Labor Code Section 2802. Next slide, please. So this brings us to the Thai v. International Business Machines Corp. Case from 2023. The decision eliminates the defense we may have used that any work from home expenses were as a result of government at-home orders rather than employer mandate and thus not reimbursable. The decision does not address the larger question that we all still grapple with what expenditures might be reasonable or necessary when working from home. A little bit of background on this case, the Court of Appeal held that employers may be liable for expenses employees incurred while being required to work from home if those expenses were a direct consequence of the discharge of the employee's duties, even when governmental health and safety orders made working from home mandatory. In this case, the plaintiff sued IBM under the Private Attorneys General Act for reimbursement of costs required to make his home equipped to accomplish his professional duties, such as internet access, telephone service, a telephone headset, etc. Previously, IBM had provided these items and services to its employees in its in-person office location. After Governor Newsom's executive order signed in March of 2020, plaintiff and other employees were directed to perform their regular job duties from home and consequently had to personally pay for the services and equipment necessary to be productive or complete their job. In its analysis, the court explained that Section 2802 is designed to prevent employers from passing their operating expenses onto their employees, and that expenses in this case were indeed operating expenses for IBM itself. this exposed IBM to large penalties for their failure to reimburse its employees. So our practical advice would be for all employers whose employees worked from home during the COVID-19 pandemic or continue to work from home today should review their telecommuting and expense reimbursement policies in light of this decision to ensure that they are in compliance with Section 2802. Next slide, please. Perfect. I'll pass it over to Mike.
All right. So we'll crank through this one a little bit quickly so we can get to some of the pay equity stuff. But we're seeing an increase in litigation based on service charges or gratuity tips in California. You've probably seen gratuity language, or whether it's out at your favorite restaurant or in the context of your employment or your employee population, language on things like contracts or restaurant receipts or menus, something about a tip or a gratuity or a service charge. Maybe you've thought that this is all the same, but now there's a lot more importance placed on the type of language that you're using and the explicit language to make it clear whether something is a tip or a gratuity or whether it is a service charge. And why does it matter? It matters because California treats service charges differently than a tip/gratuity. And we'll get into the nuances of both of those, but for the longest time, if you called something a service charge, the labor code allowed you to effectively label it as a service charge and you could treat it as such, regardless of what the customer in that situation would think. And the statute at issue is Labor Code 351, which says that a gratuity left for an employee by a patron is the sole property of that employee. In other words, the company can't touch it at all. Next slide, please. So the seminal case came down in 2019. It's a case that you may have heard of called O'Grady v. Merchant Exchange. And there, the California Court of Appeal held that just because the employer called something a mandatory service charge, that label was not dispositive of the issue. It doesn't mean that that service charge can never be a gratuity. In fact, the Court of Appeal said that you instead need to look at what the customer in that situation would think and what they intended for that charge to be. Even if you applied a mandatory service charge of, say, 20%, if that customer thought that that was actually intended to be a gratuity or a tip for those employees or workers that had helped with whatever the event was or the service at a restaurant, for example, then that should have been treated as a tip or as a gratuity, and that factors into different pay rules and different ways that that money should be transferred to the employee. It also prevents the employer from taking any portion of that. Next slide, please. So one of the recent cases that came out this year was a trial court decision in Ordono v. Marriott International, which is one of the first cases after the O'Grady decision that has really ruled on this issue. And there, based on the language that was listed on the relevant documents, the trial court here, after a multi-day bench trial, held that the service charge was actually a gratuity, that based on the evidence presented, the reasonable customer would have perceived that to be a gratuity, and it should not have been a service charge. And so to the extent the employer or hotel was keeping a portion of that service charge for their own purposes, that was unlawful, and that was money that should have been distributed out to employees. There's another case that came out just a couple of weeks ago in Gonzalez v. San Francisco Hilton that denied a summary judgment motion because the jury would have to decide what an objectively reasonable customer would have understood that service charge to be. And so this is a very heavy factual situation for all of these types of cases, especially where you have language that's vague and not directly clear that a service charge is not a gratuity. And so we're seeing a lot of the plaintiffs' bar pursuing these types of claims more and more because it is something that may need to ultimately go through trial if the language is not clear enough. Next slide, please. And so I'll kick it now to Sharday to talk about some pay equity and pay data issues.
Thanks, Michael. So now we're going to pivot a little bit to cover some of the major changes that we saw this year in California related to pay transparency, including pay data reporting and pay scale disclosures. The first major change that we had this year was the modification of the requirements for disclosing pay scales. Previously, we only had requirements to disclose pay scales upon request to applicants, but the law was amended this year to now broaden the scope of required disclosures as far as compensation is concerned for employees as well. So the pay scale in California is the salary or hourly wage range that the employer reasonably expects to pay for the position. That's the type of language that we've seen echoed through a lot of the similar pay scale disclosures laws that we have throughout the country, but there are some key differences. For California's pay scale disclosure law, it applies for any employers that have 15 or more employees, but the key is that at least one has to be located in California. So that means you could only have one employee in California, but as long as you have more than 15, you're going to be required to disclose this pay scale information to that employee upon request. Now, under California law, you have a requirement to disclose the pay scales to your employees upon request, but that's only going to apply for that employee's current position. So they can't make a request for any other positions. They can't make a request on behalf of someone else. They only are entitled to that scale for their position that they hold. You also cannot include links to the salary range in your job postings. That's a little different than some of the requirements that we have in other jurisdictions, which do permit you to use a link to the additional pay information that you have to disclose. California explicitly requires you to include that pay scale information on the job posting itself. So no QR codes, no links online to disclose that information. Next slide, please. California, of note, does not have a requirement for you to create a job posting. So there's no definition for what a job posting is. Unlike we have in some jurisdictions, they have explicit information on an advertisement or job posting. So you're using your best judgment as far as what is going to be considered a job posting. Basically, anything that you have that's advertising a job publicly is going to be a job posting. And that's going to include postings that you have that are maybe made through third parties that aren't directly posted on your website or by your company. There is no requirement to create a job posting, which means that California does not require you to create a job posting for any open position. It only requires you to include the pay scale information if you decide to create a job posting. This also is going to apply to remote positions if that position can be performed in California as well. Next slide, please. So one thing of note before we kind of hop into pay data reporting, for the pay scale disclosures for California, practically speaking, if you are a company that has locations in many jurisdictions, including some that don't have pay scale disclosure requirements, an employee, if they're friends with someone in California, for example, and they have the same job title, an employee could just ask that person to request their pay scale, and then that information could be disclosed with someone out of the state of California. So something to consider if you do have a multi-state or multi-city operation in place of what approach you want to take for disclosing pay scales. Some companies are deciding to disclose pay scales upon request to anyone who's asking. Some are being more specific depending on what the law is in that jurisdiction, but just noting that there are, practically speaking, other ways for employees to get around the request for disclosures if they're not entitled to them where they currently live or work. So just a note about that. So onto the California pay data reporting requirements, everyone's favorite topic. This had some major changes this year as well. It was passed back in 2020, and we kind of have been going through the compliance procedures and getting used to that. But this year we had the introduction of a labor contractor report as well. So one of the major changes to the pay data reporting is who it applies to, which means now it's not going to apply to anyone who has to file the EEO-1 report, but it's applying to any company that employs at least 100 employees nationwide. At least one of those is going to be in California. So that brought into the purview a lot of other companies, schools, et cetera, that maybe were not required to comply with pay data reporting in the past. Next slide, please. These are the kind of short bullet points of what the key changes are for the pay data report this year. we had an extension for the labor contractor report this year, but we don't anticipate having an extension next year. That was more so because there were so many changes and everyone was having difficulty trying to comply with that contractor report that we got a bit of a reprieve from the CRD for some additional time. But generally, the requirement is that the reports are going to be due on the second Wednesday in May, and we anticipate next year that that's going to be the case again. We won't get that extension until the summer like we had this year with the labor contractor report. Again, I already mentioned that the new scope, it removed the requirement to have an EEO-1 filing requirement, and now it's just applicable to anyone with 100 or more employees. And then the two kind of minor changes that we saw in the regular pay data report was the inclusion of a median and mean hourly rate. Very easy to calculate. There are specific instructions on the CRD's website as far as how they want you to do those calculations, but that was not really a major change that we saw in the report, but something to note anyways. The labor contractor report was the report giving everyone a headache this year, and we'll briefly cover it. You can spend an hour talking about the labor contractor report itself. Next slide, please. So the payroll employee report is the report that you are making on your employees. The labor contractor report was the report that you're making on any labor contractor workers that was working with your company within the usual course of business. The usual course of business has been kind of a sticking point for this report, and we got some guidance from the CRD. I anticipate we're going to get some more clarifications this year once the CRD is reviewing the reports and kind of seeing how compliance went, because there's still a lot of open questions as far as this broad definition of usual course of business. But there's really no bright line rule, and it takes a case-by-case analysis for you to determine whether or not you have to report on a labor contractor that you worked with. Next slide, please. So these are just kind of a summary of the penalties, and this was another new change that we had. Previously, there wasn't a lot of teeth behind the reporting requirements for the pay data reports because the CRD could only bring a claim for noncompliance and basically tell you that you need to comply. But now we have the introduction of penalties for this report, which is $100 per employee for failure to file, and then $200 per employee for subsequent failures to file. Penalties can also be apportioned to the labor contractors themselves. So when preparing that report, it takes a lot of cooperation between the labor contractors and the client employers, and you really have to start on that early in the year, basically right when we start the beginning of the new year. You want to make sure that you're in a place that you can identify your labor contractors and have a constant communication with any labor contractor companies with whom you're working to make sure that you have all the information that you need and that neither of you are going to be incurring any penalties there. Next slide, please. This summary of practical takeaways we've kind of already covered throughout this section, but essentially it's all about communication with the labor contractors, identifying snapshot periods, making sure all the people who need to know information are well aware of what's happening, and also that you get everyone involved early on so you can have a plan in place. So review what you did this year, figure out what worked, what didn't, and then make changes as needed moving forward. Next slide, please. Okay, so we're going to quickly read the CLE code. It is SS, as in Seyfarth Shaw, 2495, SS 2495. And now I'll turn it back over to Michael to wrap up the presentation.
Thank you, Sade. So we've got just about a minute left. I want to just highlight three quick cases for everybody's attention. The first case is Wood v. Kaiser. It involves sick pay claims under Labor Code, Section 245 and 248. And basically, prior to this decision, the statute allows for different recovery depending on whether you were the labor commissioner or whether you were pursuing something on behalf of the public. Notably, restitution under sick pay claims was not available for somebody on behalf of the public. And so it was only available for the labor commissioner. This case changed that, and so now it effectively allows a private attorney general under the PAGA statute to seek restitution for any unpaid sick leave or unprovided sick leave to on behalf of all these other employees as part of that representative group, whereas that option was not available before. Next slide, please. Second case is a Ninth Circuit decision that came out earlier this year, a bit under the radar, surprisingly, but it's a case in Mills v. Target Corporation, and involves what rate of pay you need to pay for employee vacation payout at the end of their employment. So under Labor Code Section 227.3, you're required to pay out all accrued vacation, earned and accrued vacation at the time of termination, same like you would for the employee's earned wages. The statute is unclear. It just references the final rate, and the Ninth Circuit had to interpret what that final rate meant, whether that was the base hourly rate or some sort of quote-unquote final wage rate that included other forms of compensation. And the Ninth Circuit held that the plain and common sense meaning of that final rate means the final wage rate, which includes not just the base pay, but also things like the pay differentials that she received when she was terminated. It doesn't go beyond that. It doesn't give us very clear guidance as to whether that means the regular rate of pay or whether it means other forms of compensation beyond just the differential that needs to be included. But it's important to review and look at your policies as to what is included in that final rate for payout of vacation, and ensure or look at whether you need to include other forms of compensation or pay at a higher rate depending on what those employees are earning. Next slide. And finally, a case involving meal and rest premium pay and whether or not there is a good faith defense. So as you all know, the California Supreme Court changed the law last year in terms of whether or not meal and rest premium pay is a quote-unquote wage that needs to be listed on things like wage statements or paid out at the end of employment that could trigger waiting time penalties. After that decision, it was kicked back to the Court of Appeal in Naranjo v. Spectrum Security, and the Court of Appeal held that there is a good faith defense to the extent you did not previously pay premium pay or include that, and that it could give rise to a derivative claim under Labor Code 203 for waiting time penalties. However, like with most good things in California, review was granted in just a couple of months ago, and that issue is going to be reviewed and decided on by the California Supreme Court probably sometime next year, and we'll be waiting that because it'll make a big difference in terms of whether this defense exists. So I know we went a little bit over. I appreciate everybody sticking around for that, and we hope you enjoyed the substance and the presentation. Of course, if you have any questions or there's anything that you'd like more detail about, our information is on the screen right there. Please don't hesitate to reach out to us. Thank you again for attending, and stay tuned for the next two parts of our CalPEX webinar series. Take care.